intellectual property rights, and how companies navigate data protection while protecting their innovations. Let's have a big round of applause. To discuss this, I would like to welcome on stage the moderation of panel discussion, Veena Arora, Head of IP Counsel, SRF Limited, Devesh Bhardwaj, AGC at Bharti Airtel. We have Dr. Parineet Kaur, who's Associate Professor from Indian Society of International Law. And we also have Jyoti Chauhan, who's a Chief Manager of IPR Gujarat Fluorochemical Limited.
So thank you, LexTalks, for inviting us for this session. And welcome all of you. After post-lunch session, we'll keep our best, do our best to keep you, awake during the session. I know that would be difficult. So setting the context, in this age of digitization, cutting-edge technologies such as AI, ML, IoT, blockchain, harbor on vast amount of data. Companies like Google, Meta, Amazon, etc., have been accumulating real-world data on every aspect of human life, be it personal, social, financial, and name it, and they have it. The quantity of data is beyond our conception. The data, which is private, an essential element of individuals' autonomy and fundamental to the human rights. An individual engages on the online platforms, digital services, smart devices, their personal data become currency of the digital world. These technologies, on one hand, hold immense promise for the enhancing the various aspects of human life, but they also carry inherent risk on security and privacy of those individuals whose data they are collecting. Individual personal information becomes increasingly susceptible to exploitation, leading to concerns like surveillance, data breaches, and identity thefts. These data breaches mandate a law regulating the access, storage, processing, and use of these data, the private data of the individuals. These regulations can have profound impact on the business and innovation of these companies. Today, we'll be discussing the intersection between the data privacy and the intellectual property rights, and how companies navigate the data protection while protecting their innovation. So before we move on to the real discussion, I would like Devesh, I would like each of my co-panelists to introduce themselves a little more.
Good afternoon, everyone. Welcome back after lunch. So thank you so much, moderator, for the brief introduction of the session. So I am Dr. Parineet Kaur, and I work at the Indian Society of International Law. Indian Society of International Law, New Delhi. It's just opposite the Supreme Court. And we have a specialized course in IPR, and also our society works in close association with the Ministry of External Affairs and also the IP office. And I have been teaching IP since I think last 8 years, and I have a PhD in copyright and competition laws. And I would like to thank LexTalk for organizing such a contemporary topic. And thank you so much.
Hello everyone, my name is Jyoti Chauhan and I am heading the IPR department of, I'm an in-house IP person in heading IP department in Gujarat Fluorochemicals Limited. So we are a fluorochemicals based company. Earlier I have experience of working with a few other in-house as an IP counsel in GSK Pharmaceutical, then Polyplex and various MNCs I was worked with, and we few the law firms. So now moving to our topic, like I have 16 years of experience and this topic was a new one. So this was very interesting and exploring the things like how it is. So the topic is, should I start the topic or should I? Okay, just an introduction. Okay, yeah.
Devesh, will you please give your introduction?
Yeah, sure. First of all, I'm really amazed to see myself on such a big screen. Thank you, a special thank you for that.
You don't look that, you look good.
Thanks for the compliment. Well, my name is Devesh. I guess it is also appearing on screen and must have been announced. I have 17 years of legal experience. Predominantly, I have worked in-house. I started my career with litigation with law firms, but I think for over 15 years, I've been working as an in-house counsel. I was lucky to work in big corporates like BMW, HSBC, American Express. Currently, I'm working as an associate general counsel at Bharti Airtel Limited and leading the Airtel Digital Limited and Bharti Telemedia Limited, which is a DTH company. Simultaneously, I'm also been taking care of another group company, which is Beetle. So that is currently what I've been, doing in my employment, and I always look forward to participate in these introduction. I mean, in these events, and just for the learning and contribution purposes. Thank you.
Thank you everybody. So before we move on to the real topic, the discussion about the confusion around data privacy and how the companies will ensure their IP while in this while these regulations are in place. I would like Devesh, if you can just throw a little light on what is the background of this data privacy.
Thank you, Veena, and thank you for giving me the opportunity to start this conversation. I just heard the word lunch once from you and once from another fellow participants. So let me just try to keep it light, just to make sure that I get attention and also able to convey what I want to speak. Privacy, like any other law, it's a man-made concept. In jungle, everything happens in open. Someone is killing someone, someone is eating someone, and it's all happening in a full private, full public view. I think if I think back and just try to, wonder how privacy was started, I think man has first introduction with privacy when the early men started moving toward caves. It might have been because of some wild animal chasing him or they're undergoing a bad weather. But first time, in my view, the previous experience would have been in a cave. And initially, they might have moved in a bigger cave with a bigger group, and later, everyone started having their families, having separate caves and separate huts. So that is how the first introduction with privacy man had. But I think the articulation of this concept, man struggled to articulate till late 1890. And I will just give you an example, like in the 18th century, when Queen's personal letter to the king were published in the newspaper, it was tried as a case of copyright infringement rather than invasion of privacy. The credit of defining what is privacy, what is right to privacy, goes to two lawyers, Louis Brandeis and Samuel Vaughan. In 1890, they first published a paper in Harvard Law Review. In 1890, it was titled as Law, Right to Privacy. It is still available on Google. Anyone can go and read it. That was the first contribution and first articulation of the right to privacy. It really played a crucial role. I mean, even when Supreme Court was pronouncing Swami judgment in para 34, they discussed about the contribution made by this article in the privacy domain. And just to share, why this was written, because Samuel Vaughan had a very personal reason to write this article. He was married into an affluent family, and in those days, press was publishing scandals every day. And he also had a gay brother, and he thought, if something wrong is published in any newspaper about his brother, then it can really tarnish or negatively impact his reputation. So this strong need really urged him to articulate a legal basis with which he can defend his brother if anything bad comes up in the press. Now, coming from the history to the current year, I mean, not the current year, last year, we finally had an act after 4 different versions of the various bills which were coming up. I think the first one came out in 2006, and then there was a white paper in Swami judgment, and we saw many versions. But in my last reading of the act, I think there are 40 plus items on which clarity is yet to be provided. I can see that it has a European soul. There are concepts like data principle, data subject is mentioned as data principle, data controller is mentioned as data privacy. But like any other privacy regulation, it talks about the data collection, consent mechanism, storage, and sharing. So I think that's a good opportunity for all of us. And I think given the size of our population, which is twice the size of entire Europe, I think in the coming years we'll see a lot of opportunities and challenges when we go forward to implement this legislation as and when it is implemented. Yeah. Thank you.
True. Thank you, Devesh, for setting this, the chronological evolution of data privacy along with this historical background. Now moving to Jyoti. Jyoti, if you could just give us an overview of what is this DPDP Act, that was enacted in India last year.
So it is recently came on 11th August 2023. So this is a Digital Personal Data Protection Act which came. So this is very important one, and I am wondering why India is so late, because in US it started, if we will talk about like every individual has some right on his data. So it should be protected in a well manner, and he has very right like on his whatever the data is submitted to the another person. It can be a company, it can be in any party. So there is a need, like if I am submitting my data to my company, so I should have a right, like I should provide first consent to the company, like this data I am providing to you, and you will be tackling it in a safe manner, and I can also evaluate like how they will be processing it, how will be safely they are, how it is safe, and I have like the right to information, so I can also cross check that how safe my data is. It is not, it should not be misusing anywhere. And I am also, if I want to modify it, I want to rectify it, so there is a right that I can have that freedom to make it any modification and then resubmit it. And how the like no misuse is there. So that type of right every employee should have, and the company should take care of all the steps. And the government has come, like in Modi government again takes the credit of this. And I have heard about like after this election, after coming this election, our digital personal data protection will be coming into force, and many companies are not following it strictly. I am not knowing why, because their penalty of 250 crore, if the company is charged, if any employee makes a complaint or the government finds that the company is not following those Digital Data Protection Act. Now the people are taking lightly. Like in my company also, I have taken many steps. Like I have consulted the HR head, another person, that why you are not taking, and you should take initiatives. Because how you are regulating, there should be a consent manager. HR should take consent when he takes, when he hire an employee. And also the NDA should be on the place, like you make a NDA with the employee, and even when the employee exit the company. So at the time of separation, you should also take, because the company also provides some data with that, like R&D is going. So how the no misuse is after the join, he will exit from us. So last day we also signed few NDAs agreements. And we will track, like it should not be like he files a patent on the same information with other company. So it should not be there. So we are taking all steps in that direction. And also we are, in our company, we are taking steps like no one can take print out without, like who is taking print of what part, no one can, we are using mobiles and emails are there. But in email, you can let me know if I'm okay. So I was just taking like whatever my thinking in easy language, so that everyone who is not aware of this, so that he can take information, because this is recent thing to all of us. So first, like the manual thing, if I'm taking this print like this paper, so information whatever is written here, it is not taking guarantee of that. But if it is a digitized means it should be in a database, it should be in computer form. Then the act come into play. So that is the first thing. Then our India, it was enacted earlier, like 2016. There were the government and deliberations were in parliament, and then the revisions were coming, like how we should propose. Now finally the draft has come into 2023. That is a very effective thing if it will be implemented after the election as it is proposed by the government. Like in all companies, it will be coming into force. There will be data security and data, no misuse would be there like the employee data, there are the many information employees submit to a company, fingerprints are there and many things, so I should give opportunity to, then I will take to other things.
Thank you, Jyoti, for providing this overview. See, the Data Privacy Act, which has been placed in India, it provides various provisions on consent, the notice to the data principal, the data fiduciary, and a new definition to the significant data fiduciary, and enhanced obligations on the part of data fiduciary. Now, moving on to Parineet, what is, your views on the international issues which are governing this intersection between the data privacy and the IP regulation, IPR rights?
Thank you so much, moderator. Jyoti ma'am has dealt with the national law, so we are going a little international now. So basically, in the introduction of this session, it was also mentioned that there is a greater reliance on digital technology now, which is ever evolving, and we are using AI, we are using machine learning algorithms. So whenever the reliance on this is more, obviously the intersection between copyright, particularly any IP, but what I am dealing right now is the intersection between copyright and data privacy law will arise. So this tension basically stems from the fact that there are certain rights of the creators which they get from their copyright legislations, and there are data privacy laws which are available to the individuals. So this inherent tension is because of the existence of these rights. So what I'm going to discuss is from the viewpoint of two people. One is the copyright owner and other are the users whose data has been used in an unauthorized manner. So if you see, are there any rights of the copyright owners in case there is infringement of their content on, let's say, digital platforms, and can they demand the data of the users in that sense? So one of the most recent judgment of the Court of Justice of European Union in 2020 named Constantine Films versus YouTube and Google. So what happened in this case was there was unauthorized upload of 2 full-length movies on YouTube. Okay, so the film distributor was a German company, and basically they told YouTube and Google to please give us the names and addresses of these people, the users of the YouTube and Google who have uploaded those movies. So the YouTube gave them certain fictitious names and addresses which was actually not workable for them, and they asked for additional data. So that was refused by YouTube. Then this case went to the European Court of Justice, and who further said that we will not disclose the data. And it finally reached to the German Supreme Court, the German Federal Supreme Court, who directed the case again back to the European Court, and they asked that whether Article 8 of the Enforcement Directive of the European Union is there with regards to intellectual property, under which national jurisdictions can actually allow disclosure of information of the users of these digital platforms in case there is a probable infringement of IP. So, but what happened in this case eventually was a very narrow and strict interpretation of the word addresses was given, that if you want to demand addresses, it is only limited to physical address. And in this digital economy and everything, the IP address and the email address was not included. So it was kind of a outdated judgment, because the court actually and the people actually believe that actually a very general interpretation should be given to the word address and not only limited to the physical capacity of address. And so if you see from this judgment, we can see that the right of the users for their data to be secure was given more prominence than a right of a copyright holder. So other case can be where the user's data is used in an unauthorized manner. So if you see recent cases, all of you are aware about ChatGPT and the company, the owner of the company is OpenAI, and it is subjected to many lawsuits now. So one of the major lawsuits was by an Italian regulator of the data. He said that there was an emergency resolution that no data of the Italian citizen will be used will be collected by ChatGPT and by OpenAI. So they agreed for some time, yeah, okay, we will not collect any data and everything. And they basically said that they had certain problems with the way ChatGPT collects data, the regulator said, and that is with respect to the GDPR, the General Data Protection Act, so regulation. And they said that the data is obviously not accurate and it has no legal basis, and also there is no regulation for people under the age of 13. If they want to use, they can use ChatGPT. So there is no tick box, nothing whenever you're using ChatGPT. So, and also there is no consent from the users for the use of their data, because these AI models, this generative AI, it's based on large language model, which basically a large amount of data is used to train these softwares. So there was no consent, and this was in European Union, and other case was in California. It was a class action because California has the most active data privacy laws. So they also filed a class suit action that obviously they agreed that the use of these softwares, use of artificial intelligence, machine learning, they will help, they will make our lives better, but they should not go beyond that purpose. And recently, Elon Musk has also filed a lawsuit. He was one of the co-founder of ChatGPT, and he has filed a case against the present CEO. So, because he said that the motive with which we created this company was not for profit, and now it has shifted the policies to a profitable business. So he doesn't agree. I don't know what is the politics. There are other various narratives why he has filed the lawsuit, but the basic narrative, he is suggesting that the profit, it was for not for profit, and they have shifted its motive of being profitable, so they are suing the company. So what we can do in this situation is, whenever there is intersection between the two laws, for being a copyright owner, I can be more aware of my rights, I can register my work, I can track down my portfolios, I should have a proper enforcement strategy beforehand. And also from a viewpoint of a user of a data or a company which is using, we should have better encryption policies. And we should actually be doing our due diligence and regularly updating our security protocols also. So that's from my side, ma'am. Thank you.
Okay, and there were other chances like GDPR, and Facebook was a famous case in 2018 where the Europe has sent very notices to Facebook, and Facebook has done many revisions into that. Like, we are submitting our data to Facebook, but how much authenticate, like anyone can make misuse. And yesterday I can also recall that it was not working for some time, if anyone can recall. So yeah, there are issues like our GDPR is also working actively, like if we are trusting on Facebook, so it should it should be safely mannered and safely handled. So that it is taking the action, and there was an Apple and Samsung patent cases, infringement suits also, where the data was leakage was a thing, like data was not handled carefully. So these are the cases like our world is taking care of, like it's our right that it should be handled carefully.
Thank you, Jyoti. Thank you, Parineet. Now, while this, the open AI is either open AI or open space AI, this thing settles. I would like Devesh to please tell us what do you think would be the practical approach that the companies can employ to strike a balance, ensuring the compliance with these provisions?
Thank you, Veena. Well, just to, the corporates are in a different scenario right now. Data privacy is coming up, and everyone is thinking how they would have to balance the processing of the data which is there in the organization, has been resting there for over a decade, and balance compliance requirement actually put up by the new legislation, and the awareness of the public, which is also developing on this subject. So I think it's all start with, by building a culture. You should have your employees should be trained and should understand the privacy related requirement. There has to be, once you have the employee training is done, you should have cross-functional teams. As and when any product is developing, you have people from compliance, legal, product, technology, so that there's a collectiveness of thoughts as and when a product is being started, or you nudge forward, or thoughts are, when people started scratching their heads, they had just to come up with any product, you have to have the trained people, you have to have the subject matter expertise, so that the efforts can be channelized in the right direction. The second pillar, which I think is that is the customer. Every corporate would be required to foster trust environment, by having a transparent consent mechanism. So as and when we are taking consent from a customer for data processing purposes, it should be very much transparent, and customers should get idea of where and on this data is going to be used, and that is going to foster and increase the camaraderie between the customers and their corporates. Once you have the entire set process, if there's an education, your customer is also trained, then you need to have regular audits and inspection so that you can identify the gaps, the risk which you can see. There would always be surprises, but I'm sure that if you have a regular audit and inspection, then you can at least, you will be able to 70 to 80%, you'll be able to cut that down on the surprise risk and exposure that may come up. Lastly, what I think is that every privacy professional should collaborate and participate in the industry events or in gathering with the ministries or the regulators, so that we get to exchange thoughts, we are able to express ourselves, we get to feel like what is going to come up in the coming years. So I think this approach of socializing within the right groups, with the government, with the expert people, shall be very much helpful. Also, when I think that, especially since the generative AI has come into our life, I think it was November 2022 when ChatGPT was launched for public. Since then, everything has been changing, and there has been a lot of data processing happening. And also recently we experienced controversy from Google Gemini. So I think right now everyone is rushing towards, to participate, and everyone is having FOMO regarding generative AI. So I think the companies who are working on these things, they should not only focus on the accuracy, but they should also have some empathy towards, privacy and fairness. And I think if any corporate is going to have a good approach, like, proactive collaboration, with leverage technology, and going to foster the trust of their consumers, they are going to balance and navigate any challenges that may come up in future. Yeah, that's my view.
Okay. So I will be adding in brief. Like in my company, I have told, like first the employee joins, so we make an NDA at the time of joining. Then at the time of exit, there is a separate NDA which we come into place in my company. So that is a company part, so I just wrote ending. So that is a NDA, the separation, like after leaving the company for certain year, he will not leak any information which is provided by the company. And we like from the inventors and R&D, in our R&D, no pen drives are allowed, no floppy drive, nothing, no CD. Even for taking a print, he has to take permission at my plant, like Gujarat Fluorochemicals Limited. And earlier, before this act has come, so there was no so much strictness, but now on my mobile, no print screen function is allowed. And if you want to take print here at my Noida office, so you have a separate, like it will be captured like you have taken print of that information, like from the R&D and other thing. So we are making such protocol like no, and there is no pen drive access in our office, and anyone who is entering, so email he can take, but if he will make a transfer to an external party, he cannot share without HOD permission or anyone, like with the colleagues. If he is sharing, so it is also monitored with the communication cell there. So these are the protocols. We are just into planning stage, and we will be implemented strictly after their work. And in our R&D, like you cannot, only the HODs are allowed to take the R&D data and experimental data and other things. No third person is allowed, because there is a user ID encryptions, there are the credential which is only the certain people are allowed. So it's not like any fresher can have access to that data.
Good, Jyoti, that the company is taking care of their personal data as well, along with the personal data of the employees. So as Devesh said that, the CFTs are important to impart awareness among the individuals whose data is being collected. and for them to become vigilant of what is the purpose behind the collection of the data, what is the use of the data, and what if there is any change in the purpose, are they notified, are they going to be notified for the data, the change in the purpose? Now recently there was in June 2023, the FTC brought an enforcement action against genetic testing company, alleging that the company retroactively altered the privacy policy without properly informing the individual and taking their consent. You know, and the FTC made this company pay huge fines because of that. So here, you know, I want to stress upon the point, the consent as well as the notice of any change, any alteration in the policies of your consent or data management becomes very important. Moving on to Jyoti, you know, we have just touched upon the various aspects of the provisions which are there in the data privacy regulations. Jyoti, would you just, you know, brief us about the special provisions which, you know, either impede or they augment the innovations by the business houses?
Yeah. So there is a section 5 of digital personal data protection where it discloses the procedures and requirement for taking the consent and notice between data fiduciary and data principal. So data principal is an individual whose data is being processed, and data fiduciary is the entity who is processing the personal data, like the company in our cases. So there is like how the requirement for the data and the procedure, like how it will be taken care of, how it will be processed, and how to exercise the right, and how to file a complaint in the cases it is not properly followed. So that is the section 5 is covering. And section 6 is there where the characteristics of valid consent is there, like how it should be taken, like it should be easy. If I want to withdraw, like consent at any time if I feel it is not taken care of in a proper manner. So I can also take that withdrawal, and the consent manager should take care of that. Like I want to withdraw because I am not having that easy. And the question was like any specific provision which I think like it will be either impede or augment the growth of IP in the time of count. So there are the provisions that could impede or obstruct or hinder or block the growth of IP. Like if I am having the R&D, so it should have like it will be followed in a strict consent requirement would be there. So if it would be like, it would be very difficult sometime, like if I don't want, I am doing a R&D, but I don't want to submit my consent, like I am on the research stage, I am not comfortable with that consent. I don't want to sign any contract, still it is like I cannot trust on anyone. How much secure it would be. So there are the challenges, like for R&D purposes it is hindering. Like next is the limitation or data transfer. Like if I want to have an external party consultant, technical consultant, or global collaboration, or I want to have an exchange of idea, or so that is like if the act will be passed, so it will be potentially limiting the growth of IP on an international scale. And third is the data minimizing requirement, like how much data should be available for the analysis, how much extent I should be having. So that is the requirement which hindering. And the provision that could augment or expand the growth of IP, like I would have positive aspect, like my data would be confidential. I would have a confidence that it would be secured in a digital platform very in a safe manner and it not be misused anywhere. So that would be the inventor would be secured that okay, I can submit my data with this consent. And there is a right of data subject, like I would have a greater control, like I have a right, like I can be I can track the data, like how much it is mannered, how much it is tracking, how much it is secure. And the compliance incentives are also like in the act, it is given other provisions, like it would be tax benefits and the grant for the commercial way for implementing robust data security measures if it will be. So there are the measures which will be also having a positive impact on IP. So there is like two things. So there should be a balance like between the to protect individual privacy and with the imperative to foster innovation and creativity in digital age. So finding the right balance will be the essential for promoting both data privacy and growth of IP in coming time.
Thank you, Jyoti. Thank you for this insightful, specific, insight on the specific provisions and how the companies will deal with these. Now, I would finally ask Devesh what he thinks is will be the emerging trends or the future considerations in this area of data protection that the companies needs to be mindful of, and while innovating and expanding their digital footprints.
Thank you, Veena. Thank you once again. Thank you for asking this question. Well, I can think of certain, trends that may emerge in the coming future. Some of them have already started, and we may get them in more details in the coming days. The first thing which comes to my mind is that, generative AI that has been creating all the buzz entire the globe. So I think very soon we can expect a regulatory framework. The MIT has been active since the last quarter of the previous calendar year. We started getting some notification from MIT recently. Also, a couple of days back, we had an advisory. So I think the generative AI shall be regulated very soon, or we shall have some kind of, binding guidelines. Second thing, I can see that the consumption of data by children is increasingly rapidly. You can see that tech is growing. Children are coming, taking their online classes. So I think maybe, in DPDPA or beyond that, we may expect, stringent regulations that are going to specifically mention how the data belonging to children should be processed, stored, or shared. Third thing, data localization. Any privacy legislation you pick up these days, whether circulated in a draft form or or in a finalized version, you will see the emphasis on the data localization. So in my view, corporate these days are very much particular about where their data shall be stored. The fourth thing that I think is that privacy paradox. All of us have a paradox. At one point we think about keeping our data safe, not sharing it. But as and when we see any cashback offer, let's say even for 10 rupees, we are willing to share everything, our janam patris, about our parents and everything. So these kind of behavior is also going to trigger a lot of complaints, as and when the regulation will kick in. Because we may get some customers who have voluntarily shared their data, but when they realize they were not supposed to do, or they are, they can leverage the position of the law. So I think consumer complaints may increase. Yes, the fourth or fifth thing could be is that yes, suddenly there would be increase in demand for people like us. We would be needing to have privacy professional in the organization. So I think these are the trends that I think we may witness in the coming days. And yeah, that's it from my end.
Thank you, Devesh. Recently only there was a case, in the European Union where there was a either pay or agree, These coercive agreements will be there, the consent management of this kind will come into place. And what will be the role of, these regulations, and how the companies will navigate through these regulations to protect their innovation? That will be clear in times to come, and it will take a while for things to settle down. So while data privacy regulation will foster innovation, we haven't touched upon various areas where these data protection enactments will actually foster innovations. This will give a platform for the companies to provide solutions which will be, the data privacy, which will be more compliant to the data privacy regulations, like encryptions and anonymization of the data, encryption of the data, and the consent management of the data. So these solutions will be the innovative solutions which will augment the innovation in this direction. On the other hand, there will be which will make this platform more safe and secure by providing different security, cyber security measures such as encryptions that I just said, tools for anonymization, and provide access control to the data principal. However, it remains to be seen how companies prioritize the data ethics and be accountable to the access, use, and accuracy of the data while maintaining the legal rights of the individual. So this confusion will settle in time, and it will take some time to settle down. With this, we close this session, and the floor is open for any questions, please. Yeah, sure.
Reform wishes to all. We do live in a world where data privacy is just a myth, and we can definitely say that European Union is enforcing such things on these companies only because of one thing, that because citizens are well aware of their rights, citizens are well aware of that what the infringement of privacy is. But in a country like India, the Data Protection Act has been enacted upon. But right now, in the ground reality, means what about the awareness which we are having about all these things? Because company will always try to infringe upon the rights. It is completely up to the government. The onus lies only on the government and not on the citizens to just enforce such laws and to make it more enforceable.
See, I can just add on to your concern. See, I was reading a paper that day in which it was clearly indicated that though Europe, they were the first one to enforce these data privacy regulations. But believe me, they have, because of these data privacy regulations, they have lagged behind providing many AI solutions behind US and many other countries. So see, everything comes at a cost. And what we need to decide here is what is the cost behind. If the data, in the morning itself, there was a gentleman who was, we were having this discussion. He said, see, data privacy, what is it? If you are, if I'm just monitoring, I'm standing outside your house and just monitoring your movement, I'm monitoring what you're ordering from outside, which place you're ordering from. Do you think it will come under your data privacy? So I was I was confused. Does it come under the data privacy? Do we have certain regulation? Then why are we enforcing these regulation on the marketing platforms then? So that is, these are my views. I think Jyoti may differ here. Okay, Jyoti, if you would like to add on.
Yes, so I was saying there was a case in my IT company, so there was our company data. So we have requested like a digital signature or other thing to another party. So they have sent us an email and they have asked, there is a click, like consent letter, if I will click that yes. So they then and only they will share with the third party. So, and also the banks are strictly followed, like your any information, if you will ask, like I want to make a that national pension yojana, so Airtel scheme and another thing. So they will not do it without having your consent. So they are like it will take time, like our nation is just waken up, like in this act I will say, we are already late. So, but the things are moving fastly. So we have up and we are moving on the right track in the hospital, and there are the significant so they are strictly following, banks are following, third party vendors, if you will say like share my information with the bank and I want to do this. So they will take your consent. So they are following, and we have to take some patience, like it will be implemented very soon.
See, here we need to be mindful of what do we call as private data. That is if we define this private, the word private, this conundrum will settle soon. Devesh, if you have anything to add on this?
Well, I concur with all the thoughts, nothing additional to add from my end.
Okay, anybody else? Yes, please.
Good afternoon, ma'am. Thank you so much for such an insightful session and for sharing your experiences and your thoughts on this topic, which is very, very relevant. What I wanted to ask you was that in today's day and age, when we say data is the new oil, and all the companies and every corporate has to mine that new oil and data in order to grow their business, and they protect their data very, very well, though, in all of their airtight contracts and the sensitive information and business plans and all of those things. So when it comes to the data of the customers or the clients, there has to be a balance that has to be struck with the rights of those clients and their digital privacy rights, their right to not get their private information out there for any other purpose other than what they have consented for. So where does the balance lie, and how difficult is it going to be for the corporates and the companies to ensure that balance? That's my question.
I would just say, we'll have to wait and watch for this legislation to be enacted and some, case laws to develop, and then, we can dwell upon that precedences which develop during this time. So I would just say that at present, nothing can be said for sure. You cannot say anything for sure. Thanks.
Thank you.
And another thing, like it is a digital, so you should know like anything. I think it is like private, and I am sharing with the customer verbally. There is no proof, so you have to make it digitized. So first part of this is like digital personal data protection. So you have to make it in a database software that way as well.
Yeah, and if I may add something,
Yes,
well, am I Veena?
Yeah, sure. Please,
Yes,
please,
yes,
Devesh.
please.
I'm not present there. So, see, recently there is a report out on last Friday by Blue Ventures. It's an Indus Valley report, and it talks about how diverse our country is. So when we say having a cell phone is also luxury to many people in this country, and this country we may say that we are 150 crore people, but the actual market size where people are ordering from Zomato, Swiggy, enjoying all the benefits of IoT things, that's a market of only 30 million. So I think we are a very diverse, socially and economic basis also. We are a very diverse country. There can't be a straitjacket formula. I'm sure there would be exceptions to the legislation, or when we have the welfare schemes like DBT, how the benefit of the technology can be given to the poorest of the poor. How can they be included in this 30 million list? So I think we can't have given a complex and diverse country like us, we can't have a straightforward formula for all of us. So I'm sure that, as and when we progress in our journey of digitization, privacy, we will see. I think it shall be a very inclusive journey and very flexible journey. This is what I think. Yeah.
Thank you. Thank you, everybody.
So this is not a final one. There may be like we will be advising to policymakers, so we will be revising it according to the needs. And there are exceptions which is in this act which I was going through. Like if there is a medical extreme emergency, like this person is not conscious, and we have to give his data. So the concerned manager will allow and provide that information. And there are a few exceptions to that.
If there are no more questions, we end this session, and thank you all for being patient listeners here. Thank you.